Hi, welcome to Mondays with Melissa. Today I thought I'd talk a little bit about trusts and revocable trusts versus irrevocable trusts. It seems to come up quite a bit and many people still don't understand the difference. So in our area of practice, a revocable trust is often used for the purpose of avoiding probate. But it's revocable, which means you can undo it, you can take it back, you can pull the assets out of it. If you are creating the revocable trust, you still have all the control over the assets. The nice part about it is when you pass away, everything in the revocable trust passes to the beneficiaries of the trust and does not have to go through the court system or the probate process. And it becomes a huge advantage, especially if you have family members who perhaps don't get along, or you're leaving someone out of your estate plan, you're disinheriting someone because you don't have that forum then in the court during a probate proceeding. There's no waiting period like there is with probate. So most estates are going to be open for at least 7 months, probably more, before the assets in the estate can be given to the beneficiaries. Where with a revocable trust, the assets pass directly to the beneficiaries at the time of the individual's death. So if you want to get assets to your family members more quickly, let them have access right away, the way to do it is with a revocable trust. However, you're also going to want to have a will, which we refer to as a pour-over will, that basically says that if there's anything left in your name at the time of your passing that's not in your trust, that it will go into your trust and pass that way through your trust. So that way you're really covered in making sure that everything passes the way that you want it and the way that you lay it out in the revocable trust. The one thing that a revocable trust doesn't do is protect your assets for long-term care purposes. And that's what the irrevocable trust is typically used for in the elder law practice. There are different types of trusts that are irrevocable that might be used for estate tax purposes, but for the purposes of elder law and asset protection, the irrevocable trust is the main tool that we use for asset protection. So it does the same thing as the revocable trust in that you are avoiding the probate process because you're putting assets into a trust that are going to pass outright to the beneficiaries outside of any will or any probate. But it's an irrevocable trust, so it's not quite as easy to undo it or pull assets back or take assets out of it. The idea behind it is protecting the assets in case you need care in a nursing home or if you need care at home sometime down the road. So taking away some of the control is necessary. But if the trust is drafted properly, you're still able to retain some control so you can tweak the trust if necessary to ensure that everything is carried out the way that you want it. But again, it has to be drafted properly in order to do that, and it has to be flexible, which is why it's so important to work with an attorney or with a firm that practices in this area because it's very specific language that's required. The irrevocable trust gives you less control over the asset, but asset protection for long-term care purposes. The revocable trust allows you to have full control over the asset, but doesn't protect it for long-term care. And those are really the main differences of the revocable and the irrevocable. Most of this information is contained in our ultimate guide to trusts, estates, and elder law. There is a link below. You can download it or give us a call if you'd like a hard copy. Put any questions you might have in the comments. Always happy to answer them, and we'll see you next week.